Okay, this week we're going to talk about dissension in the closely held corporation. I apologize, I'm presenting this in a different mode than usual because I have some mobility issues. This is being posted to YouTube, so you can watch it at your leisure. Also, Group 1, you'll be glad to know you're off the hook since I'm doing all the talking today, but I'll get even with you later. You'll have to advance each one of the slides to hear the narration that goes with it. In other words, the slides are not going to advance automatically. You'll have to manually advance each slide. I think that will be apparent when this thing gets put up on YouTube. Okay, we're talking about chapter 13 of the text, selections from it. And we're going to look at some other kind of practical aspects of resolving these types of disputes in closely held corporations. First topic we're going to talk about is deadlock. We've alluded to this before during the semester. Many corporations are formed with 50-50 ownership. Why? Why is that? When even numbers of shares are on each side, we always have the potential for deadlock. And why do we even set ourselves up for that type of a situation? There are a number of reasons that companies get set up in 50-50 or equal number of shares owned by the owners. One of them is a general sense of fairness, and the perception being that we're in this together, we're partners. And remember, this whole idea of closely held corporations is analogous to partnership, and we've talked about it that way in the text and the law. Look at close corporations almost as partnerships. So the concept of being in this as equal owners, as equal participants, is one of the basic reasons that companies find themselves in this situation. Just a general sense of fairness and equality, especially in an early stage company. Another reason that we see companies set up as equal share ownership is simply out of fear of confrontation. Early stage companies, oftentimes no one wants to offend the other person. They don't want to start out right out of the box with someone knowing they have a majority and the ability to influence everything that goes on. And so oftentimes, to diffuse that potential power play, owners will simply say, look, let's just make it 50-50. Again, not a particularly logical reason for it, but as a practical matter, that's another reason. So fairness for one, avoidance of confrontation is another reason. Another reason that you'll see this sort of division is sometimes it'll come down to a division of labor. One entity is bringing the capital to the enterprise, and the other one is perhaps bringing skills or other resources that are valuable. And again, the parties will make a somewhat inexact measurement of those respective values in terms of making the ownership 50-50. Some other reasons that pressures that lead to dissension in closely held corporations, not specifically related to the mathematical equality of ownership that we've been talking about, but oftentimes there are families involved in these businesses, close family ties or personal ties to other investors that would suggest that it's probably in the best interest of the non-family member to have some protections in place. Sometimes there's a mutual trust, sometimes there's lack of mutual trust. Sometimes the owners coming into the business are strangers until they formed this business together, and so there is a need to create some protections in that relationship. Another reason to add some of these protections to a new company shareholder agreement is perhaps uneven sophistication in business matters. You may have one of the owners who's the capital person who is in fact fairly sophisticated in business, and the other partner or the other owner may be someone who's simply the skill set that you need to have, and may not have a lot of experience in business entities or business transactions. Another reason to consider building some of these safeguards into one of these agreements. And then, of course, we always suggest these types of safeguards simply because no one knows for sure what's going to happen when a business is formed. I will tell you that every single business that I've formed, when I've sat down with the principals to set up the business for the first time, there is no shortage of optimism and confidence in the success of the enterprise. Everyone starts out that way, just like a marriage. For lots of reasons, it doesn't always end up that way. And one of our jobs as lawyers is to anticipate that possibility and to build those contingency mechanisms into the document that orchestrates the relationship. We're going to talk a little bit more about those in a little bit. Okay, let's talk a little bit about the Gearing versus Kelly case on 737. This is a New York case from 1962, and this had a fairly convoluted cast of players, as I recall. We had the Radium Chemical Company, owned by 50% owned by Gearing, and 50% was owned by the other side of the founding families, the Kelly family. There apparently was, as is with a lot of these small businesses, some bad blood, and that's what drove the one shareholder to fail to attend a meeting at which a replacement director was going to be elected. The bylaws of Radium provided for 4 directors. The directors were Kelly Sr., someone named Lee, Mrs. Meacham, who was a successor to her father. We eventually had Kelly Jr. elected to the 4th slot. Lee resigns, and so we have an election to elect Hemphill. And Meacham decides not to attend that election, even though it's clear that she had notice of the meeting. It was not inconvenient. With a lot of these cases, we don't get all the facts, but suffice it to say there's some bad blood and there is some spite in this decision, and so she doesn't show up to vote for the directors. And Mrs. Meacham now asks for a revote on the election of Hemphill as a director. So what was the actual vote at the meeting? Let's assume we had one shareholder show up of the 2, and so it was a 50% vote in favor of Hemphill's election. Gearing was asked the court to invoke a section of the New York General Corporation Law, Section 25, which allows the court to order a new election, quote, where justice may require, end quote. In other words, this is a somewhat open-ended, equitable, judicial solution for situations of corporate governance that simply make it unfeasible to elect directors, or elect officers, or anything else that's supposed to take place from a corporate governance standpoint. The trial court in this case said no, we're not going to order a revote, and the appeals court affirmed. This court affirms as well, and says that Mrs. Meacham, your unclean hands contributed to the problem. That is the result that I think we would expect. It seems somewhat commonsensical. They were trying to be creative in getting the court to rely on this provision that was fairly open-ended, but when you contribute to the problem, when you contribute to the lack of a full contingent of shareholders voting on the vote, the election of the directors, you don't get to get a redo. The court was not going to step in and use this extraordinary judicial mechanism to correct what is essentially dysfunction at the shareholder and board level of this closely held corporation. We did have a dissent in this case who felt that perhaps there should have been some judicial intervention of some kind in this case. But I think this case stands for the basic principle that when we have deadlock, courts are loath to get involved if they have a clear roadmap for getting involved. They will, as we'll see in some of the other cases, but here, where one of the parties has contributed to the dysfunction leading to this irregular election, the courts aren't going to get involved. This court was not going to get involved. Shame on you, Mrs. Meacham, for not participating in the corporate governance regimen that you signed on to when you became an owner of the shares of the company. Okay, let's move on and talk a little bit about the couple of other things. Touched on gearing. We went through who the players are. Again, this is a family dispute. We have people sabotaging the corporate governance process. We had a bylaw in this case that the court used to get some guidance in whether or not it should get involved in the decision. And we had a statute that the court relied upon, at least decided not to use that statute. I would suggest you want to take a look at the dissent in some detail and look at the reasoning there. The fact that the dissent points out that this really was not even a quorum of the shareholders, it was only half. And the fact that the dissent points out there might have been other remedies to resolve this dispute. For instance, a new election at the next annual meeting. But it was the dissent. Okay, let's move on. We have a statute in Ohio that deals with what happens when we need to replace a director midterm. 1701.58F. Remember, 1701.58 was the provision of the code that we talked about previously that talks about how directors are elected generally. And so we've had reason to look at this statute before. And with some of these statutes, as you'll see, at different times in the semester, we'll look at different parts of them. Now we're focusing solely on the replacement of a director midterm. So our statute says, unless the articles or the regulations otherwise provide, and again, this is hearkening back to my comment at the beginning of the semester, there will be times when you need to build things into your articles or regulations. Unless the articles or regulations otherwise provide, the remaining directors, though less than a majority of the whole authorized number of directors, may, by a vote of a majority of their number, fill any vacancy in the board for the unexpired term. So what does that mean exactly? That means you could conceivably have the resignation of a director. You could have whoever's left, a majority of that number appoints the replacement director. So it could be substantially less than the total number of directors that were originally elected. So maybe less than the majority of the whole authorized number, but a majority of that number of directors can fill the vacancy for the unexpired term. And of course, we say unexpired because every Ohio corporation has an annual meeting in which directors are elected. And so at the next ensuing election of directors, there'll be a permanent, or at least for the next year, director elected by the shareholders. Okay, and the next section talks about the fact that a vacancy may exist because of an increase in the number of directors. That doesn't really apply to the situation we had here. But our black letter law is, unless the articles and directors provide otherwise, the remaining directors, a majority of the remaining directors, can appoint the director to fill the unexpired term. Have we applied this to the gearing situation? How would we have come out? Probably about the same. Our statute allowed the remaining directors, even though less than a majority, to appoint a successor for the unexpired term. I submit it would have been the same result. Our statute's a little bit different, obviously. Ours is more mechanical than the very general equitable solution that was provided by Section 25 of the New York statute. All right. Let's talk about the Radom and Neerdorf case on 739. What's going on here? This was a music company. They did lithographing or printing of music, and for about 30 years, Neerdorf, husband of Anna Neerdorf, and David Radom, brother-in-law of Neerdorf, and brother of Mrs. Neerdorf, were the sole stockholders, each holding 80 shares of the company. So if you've diagrammed this one like I have, we have brother and sister, each owning 80 shares of the company at the end of the day. Again, we have the potential for deadlock here. Another situation where we have a family connection, where we have this sort of dissent that we often have in family situations. In this case, I believe there was also a derivative suit filed claiming that one of the owners was being unjustly enriched. One of the shareholders files for judicial dissolution under Section 103 of the New York General Corporation Law. And we have a picture of that statute on Section 103 on page 740, which says that unless otherwise provided in the Certificate of Incorporation, again, another reference to the Certificate of Incorporation, if a corporation has an even number of directors who are equally divided respecting the management of its affairs, or if the votes of its stockholders are so divided that they cannot elect a board of directors, the holders of 1/2 of the stock entitled to vote at an election of directors may present a verified petition for dissolution of the corporation as prescribed in this statute. Everybody knows what a verified petition is. I hope it is a complaint that's actually signed by the parties and not just signed by their lawyers. It is a way for the court to hold parties accountable, more closely accountable with what's going on, instead of it being filtered through their lawyers. Okay. What was the evidence of deadlock? What was the evidence of deadlock in the case? It appears that the company was doing pretty well. They were profitable. They had a lot of feuding and backbiting, but there wasn't really any stalemate or impasse as to corporate policies. It was doing pretty well. There were some lack of cooperation, but the company was functioning. It wasn't like some companies where you absolutely can't conduct any business at all because there's an inability to make the most basic business decisions. Nonetheless, the trial court granted dissolution in the case, and the appeals court reversed, citing the profitability of the company and the fact that, as I just said, it's been functioning. It doesn't appear to be a situation of functional deadlock. So it comes up to this court, the appeals court, and the way this court comes down is they reverse, and they affirm the appeals court in saying that there's no absolute right to dissolution. It's really, at least under this statute, the way they read this statute, Section 103, it was within the discretion of the court as to whether they were going to grant the dissolution or not. And we go back to the statute. The trigger here is if there's an even number of directors who are equally divided, respecting the management of its affairs, that obviously has some room for interpretation. Does that mean that we're not making the best decisions? Does it mean we can't make any decision? Is it a qualitative analysis of lack of management and cooperation? This court reads it to be a somewhat qualitative decision that the court has the right to exercise some discretion. The prime inquiry, according to this court, is whether the dissolution is beneficial to the shareholders and not detrimental to the public. And in this case, clearly the business was still profitable. So from that perspective, it was still beneficial to the shareholders. As to the detriment to the public, were people being put out of jobs? Would people be put out of jobs? Probably. Would contractors and suppliers lose business? Probably. So chances are that this court's determination is that there's no absolute right to it. The prime inquiry suggests that the shareholders are benefiting, and that it would probably be detrimental to other stakeholders to dissolve the company. And we did have a statute here. Now, one of the things that the dissent points out on 742, they took the position that this clearly is going to end up being long-term deadlock. We may have a low-level bickering at this point. We may be profitable, but chances are, with this type of evidence, this is going to end up being a situation that should be dissolved. In other words, this judge's discretion would come down on the other side of it, suggesting that the seeds of permanent dissent are here, and we should dissolve it now. The dissent also points out that Section 103 criteria don't really allow for the court to consider the profitability of the company, not literally. And as we looked at the language before in 103, it is fairly general. It just simply says that the management is divided respecting management of its affairs. It doesn't talk about profitability being a factor at all, even though the majority did cite that as one of its factors in denying the dissolution of the company. So, interesting perspective. This one providing for a kind of a qualitative decision on the part of the court as to whether there is in fact the type of deadlock that justifies dissolving the company. Because when a company is dissolved, there are lots of ramifications from it. As I said before, there are stakeholders that are impacted by the closing of a company, not just the shareholders. In a few minutes, we're going to talk about our judicial dissolution statute in Ohio for 170191. We're also going to talk about it later in the semester. I believe we have a whole section we're doing on kind of end-of-life issues for corporations, and we'll talk about judicial dissolution in that class later in the semester. But we'll talk about judicial dissolution in a few minutes in the context of this particular chapter as well. All right, so you've probably gotten the idea from what I've been talking about that you always have a choice when you form a new company, whether it's a 50-50 corporation or some other kind of closely held corporation. You always have the ability to write into your shareholder agreement the rules for handling deadlock or any other kind of dispute. This is the way to control the process. This is the proverbial pound of prevention is worth a ton of cure. If all my clients had shareholder agreements with these mechanisms in it, the world would be much simpler for all of us, and I wouldn't make as much money, of course, but this is a simple way to create a roadmap for resolving disputes among closely held corporations, is building in dispute resolution mechanisms into the shareholder agreement. So let's look at a few. I'm just going to mention a couple of different ones that I like. One of them is the third-party decision maker, and I'll just read you the clause that we use. In the event that any issue related to this agreement cannot be consensually resolved by the shareholders, then in such event, the parties agree to each pick an individual within 1 week of reaching a deadlock, each called a designated shareholder representative, and the two designated shareholder representatives shall within 1 week of their appointment select a third disinterested individual who shall decide the disputed issue. If any costs associated with this process are incurred, each shareholder shall pay an equal portion of any such costs. So this one provides a mechanism where each shareholder picks a rep. Those reps pick yet another person who is presumably 2 layers removed from the original shareholders and also disinterested, as were the second tier designated shareholder representative. And the idea here is that we put some distance between the disputant parties and the decision maker, and of course we add some pain in the form of sharing of costs, and that sometimes is a disincentive for people to continue to disagree. Another clause that we use sometimes in these contracts to resolve disputes is an arbitration clause. So here's an arbitration clause from an agreement we've used in the past that we like. Quote, in the event the shareholders are deadlocked on any decision relating to this agreement or the operations of the company, the parties shall negotiate in good faith to resolve such deadlock within 10 days. If the issue is not resolved within such 10-day period, then either party may engage, at the company's expense, a single arbitrator under the auspices of the American Arbitration Association, AAA, to resolve the deadlock. Neither party shall be entitled to select the AAA arbitrator who will be selected by the AAA. The costs of such arbitration, i.e. the AAA fee and the fee charged by the arbitrator, shall be borne by the company, provided, however, that each party shall be responsible for paying its own legal fees, if any. This one turns it over entirely to a third party to make the decision for these shareholders who can't seem to get along. It creates some significant pain for the company because despite what people say, arbitration is not cheap. You have to pay the arbitrator, oftentimes several $100s an hour. You have to pay the AAA to administer it, often, again, several hundred, maybe several $1,000s. And again, this sometimes causes people to become reasonable when they see that they're going to have to pay someone to work out an issue that they really should be able to work out themselves with the other shareholder. But again, having this in a written agreement is a great way to move people toward consensus once they realize what they're paying for this. Another clause we use is something called a Russian roulette clause that we put in a contract. This says, for instance, either owner can offer to purchase the other owner's shares at any time. The offeree can either tender his shares at the offering price when the offer is made, or require that the offerer purchase the offeree's shares for the same price. How does this work? I write a letter to my co-owner and I say, I'd like to buy your shares for $1,000. We're not getting along. I want to buy your shares for $1,000. My co-owner has the right to say either, okay, you can buy my shares for $1,000, I'm out of here, or he or she can say, I'm going to buy your shares for $1,000. What this does is it keeps people honest because they're not going to make an offer for a price that is not fair if they know that they can be bought out for the same price. Follow? So this is a great mechanism to keep everybody honest and to create a liquidity event when things just are not going well and someone needs to get out. This creates some liquidity. Now, of course, neither party may execute take up the offer to buy out the other one, in which case we're back to the judicial dissolution scenario, perhaps. But I've seen this Russian roulette clause used in the past, and sometimes it does free things up and move things off center. And then, of course, another clause we use in these is the liquidation clause. It simply says, if the parties have reached a deadlock that cannot be resolved within X number of days, and we can add all sorts of bells and whistles, for instance, and the issue is significant enough to prevent the company from operating, etc., or the issue affects a material part of the company's business, you can draft all kinds of specifications into that condition. In that event, the company will go into liquidation mode and will dissolve. And we'll talk about later in the semester what that entails. Very short description is that you cease operations, you wind up all contracts, you sell off all machinery and equipment, you pay off debts, and you distribute the money to the shareholders pro rata, kind of like a nuclear bomb. And that is a provision that we build into these as well. This idea of simply a liquidation mechanism in the event that we're not able to resolve a dispute. All right. That's deadlock. Let's move on to the next topic under this chapter, and that is the idea of oppression. We've talked in the semester already about the fact that owners of close corporations owe certain duties to each other, and fiduciary duties even, of fairness in dealing with each other, and full candor when dealing with each other. We also have situations where in close corporations, majority shareholders exercise not only the power that they're entitled to purely by virtue of their ownership, the magnitude of their ownership of shares, for instance, but perhaps instances where that majority power is used in a way that's, I'll just say, unfair and oppressive to a minority shareholder. This comes up a lot because as much as we've talked about 50-50 shareholders, there are many companies that are not 50-50 shareholders, and that's for a wide number of reasons. If I start a company and I've put all my money into it and I've put all my sweat into it, and I decide that I want to take in a co-shareholder or a partner, I'll just call it a partner generically for some reason, then I might not want to give up control. I probably wouldn't want to give up control. I might want to sell a minority stake in my company because I need the cash, because I need the expertise, because I need something else, but I'm certainly not going to give up all control. So that's one of the situations that sets up this minority-majority dynamic that we're going to talk about in the section here where we talk about oppression. That brings us to the Donahue versus Rod Electrotype case out of Massachusetts from 1975. Here's a situation where, again, we had a founding family that formed this business. They had been in the business for a long time. And as often happens, there were advantages given to the founding shareholder that the other shareholder wasn't entitled to participate in. So the minority shareholder sues to revoke or reverse a redemption of the founder's stock. Remember, a redemption is where the company buys back shares from a shareholder. And in this case, one of the founders had his shares redeemed, and at a price that was pretty advantageous. The claim was that this redemption violated the director's fiduciary duty to the plaintiff shareholder. The plaintiff shareholder apparently wanted either to be bought out also or to dispute the price at which the buyout occurred. And as a shareholder, I'm sure the argument goes, this is my company too. You can't use my cash to buy out this person without it being in the best interests of the company and being good for me as well. Trial court dismissed the complaint, and the appeals court affirmed the dismissal. What had happened here was the founder had negotiated with his family for the redemption of his shares, and when the plaintiff requested the same deal, the plaintiff was denied. Plaintiff, I have to look at the facts again, I'm fairly sure was a minority shareholder. Yep, Euphemia Donahue, a minority stockholder. Now remember the problem here. This is a private company that has, in which a minority shareholder has an illiquid locked-in investment. The only way to realize cash for that ownership stake as a minority shareholder is to be bought out by one of the other shareholders or by the company in most cases. And remember, we looked at shareholder agreements that have those restrictions on transfer, those rights of first refusal that greatly curtail the market for shares, a minority stake in a private company. So by the plaintiff not being able to be redeemed the same way, she's locked in. She doesn't have a right to liquidate her investment. Classic minority shareholder argument. And so she's claiming, an unlawful distribution of corporate assets, breach of fiduciary duty. This court reverses and finds in favor of the plaintiff. Why? We've got a good discussion that echoes a lot of what we've talked about already, but it's worth kind of pounding in the point here because it's important. And as a practical matter, it becomes very important in practice. This happens all the time. Close corporations have a small number of stockholders. That's just how they are. Sometimes it's just a handful of stockholders. There's no ready market for these shares. Most people would not want to buy a minority stake in a privately held company for all the reasons that we've just talked about. What the heck am I going to do with this? Even if there's a buyout offer to have someone buy the company, who knows whether my minority stake will have enough voting power to approve that transaction. If the majority shareholders refuse a buyout offer from a third party to buy the company, I'm still stuck. If the company decides they don't want to buy out my shares, I'm stuck. And oftentimes, again, the court talks about majority shareholders in these closely held corporations typically runs the management, typically runs the company, typically makes all the decisions affecting the day-to-day operation. Here, I remember I mentioned at the beginning of the semester we were going to hear from the Salmon versus Meinhardt case again, or Meinhardt versus Salmon, and of course the court cites to that case here, says that joint adventurers like co-partners owe to one another, while the enterprise continues, the duty of the finest loyalty, and they liken it to a partnership, how the relationship among shareholders in a closely held corporation must be based on trust, confidence, and loyalty. So nothing particularly surprising, but this is a good factual setting to see exactly how this in practice really plays out sometimes. Oftentimes it's a family member. Oftentimes a refusal to issue dividends. And we'll talk about a few more of the factors in these freeze-out situations. And on page 748, the text gives us some good description of some of these mechanisms that get applied to squeeze out, freeze out minority shareholders. And oh, by the way, why do we want to freeze out or squeeze out a minority shareholder? What's the end game here? Again, let's assume bad blood. Let's assume everybody hates everybody else. The job here, if you're trying to freeze out someone, a minority shareholder, is to make it so uncomfortable, financially disadvantageous, so that they want to sell their shares to you at some sort of a deep discount. It's to put so much pressure on the minority shareholder that they will sell to you at a lower price than they really deserve, making your life difficult as a minority shareholder. That's really the strategy behind these types of situations, and I see this all the time. So here are a couple of ways that this sometimes gets applied. Let's say the minority shareholder works for the company. Not uncommon. Maybe that person's only job, maybe their only source of income. The majority shareholder decides, okay, well, let's see. I'm the majority shareholder, therefore I can appoint the board of directors that I like, and the board of directors who runs the company and hires the staff just decided that they don't need you working here anymore, you're let go. Now, if this is your only job, chances are if they come up to you a week later and say, wow, you must be hurting these days, no income, how about if we take those shares off your hands? You might sell. Another scenario in the freeze-out realm that we see is, remember we talked about the fact that directors determine distribution of profits, that is, dividends. We looked at that early in the semester. Let's say the majority shareholder, who again has the power to appoint a majority of the board, and it so happens that the majority shareholder is independently wealthy already, decides, you know, we're not going to issue a dividend this year. We're going to keep the money in the company. And you as a minority shareholder, it may be you really rely on those profit distributions every year. Chances are you do rely on those profit distributions every year. If the directors make a decision to not declare a dividend, not to distribute profits, that could have the effect of a freeze out on you. If they come up to you early the next year and they say, wow, you must be hurting since you didn't get that dividend, can we take those shares off your hands? That's how that would play out. I will see later in the semester that there has to be some, there can't be a bad faith, a failure to declare a distribution, but this is a freeze out technique. Another one, let's say that you are a minority shareholder and that you are also a director or an officer. And as such, you're empowered to exercise certain powers and make certain decisions under your articles of incorporation, under your bylaws, maybe even under the corporate statute in your state. And the director decides, the majority shareholder decides at one point, you know, we're going to have a new election this year and you're being voted out as a director. In other words, being removed as a decision maker in the corporate structure by the majority shareholder. This is another classic freeze out technique to essentially put you in the dark, or at least put you more in the dark than you were before about what's going on with the company. And eventually they may come up to you and say, wow, I haven't talked to you for a long time. Hey, you interested in selling those shares? And they might do that because they've been in the dark. Another couple of other things we see in the freeze out world is barring access to books and records. Now, you and I know that barring access to books and records is not a winning strategy long term. We've talked about it a little bit at the beginning of the semester, and we're going to talk about it more later in the semester about access to books and records being one of the hallmarks of ownership of common shares. But it doesn't mean that unscrupulous shareholders don't try this all the time in order to require that the minority shareholder, who maybe doesn't have a lot of money because they're already being screwed, causing them to hire a lawyer to insist on their rights as a shareholder, to see the corporate records. Again, this is a freeze-out technique that is sometimes used to put the minority shareholder in the dark so that they're either worn down by litigation or give up and decide to sell their shares. And we've seen some other techniques we see are, for instance, cutting off the health insurance for a minority shareholder who happens to work for the company. Again, that can be a pretty sticky one to prove. If you can make an economic argument that it's not in the best interest of the company to carry health insurance. I have seen it used as a freeze-out technique on my clients before. Even when they had terminal illnesses in their family. In those types of situations where these types of freeze-out, squeeze-out techniques are applied, the plaintiff, the minority shareholder, is going to be coming in asserting breach of fiduciary duty on the part of the majority shareholder. And in this case, again, the court cites the Meinhardt versus Salmon language and says that, quote, we hold that stockholders of closely held corporations owe one another substantially the same fiduciary duties as partners. Okay. Now, a quick tangent on that. Remember that we talked about preferred stock earlier in the semester, and that there are times where redemption of stock is provided for in the Articles of Incorporation. All redemptions aren't the same. Some redemptions are provided for by the characteristics of the shares themselves. In the Articles of Incorporation, we could have redemption provisions that eliminate any argument of breach of fiduciary duty. So it's important to understand what types of shares we're talking about, whether there might already be a redemption provision baked into them when they were created versus a garden variety type of redemption argument. Okay. Now, speaking of that, remember we had 1701.35. Since I'm working off of PowerPoints, I can't go to the hyperlink because I can only capture this slide, but I will encourage you to go to 1701.35, look at the mechanisms for redemptions under Ohio law, and you'll see that there are things like it has to be decided by the board of directors. There has to be some economic reason for it. There has to be sufficient surplus to be able to fund the redemption, etc., etc. So at least here in Ohio, we do have some statutory mechanisms to control how redemptions take place. Granted, this was just one part of the Donahue case, but again, always look to see if we have a statute on point. I just want to make a couple comments on this idea of employment management and dividend expectation in closely held corporations, and I just repeat it because this really comes into play as the primary motivation in a lot of these disputes that come up, and when we have these situations of oppression. Given the illiquid nature of ownership in closely held corporations, employment is sometimes the primary benefit, relative job security of being employed by the company that you formed. That is one of the very main reasons that we form these companies. We take out salaries, and we also get dividend distributions. We typically are compensated a couple of different ways when we form a closely held company. So it's not like a regular job. It's a job, but it's a job you created when you formed the company, and therefore when the security of that job is abused by the power of a minority shareholder, it is serious, and courts don't look kindly on it when they're trying to determine these cases of breach of fiduciary duty. And same for dividends. No one relies on dividends from public companies for living expenses. At least most of us don't. With a closely held corporation, you do rely on those distributions of profits. That is one of the primary revenue streams coming out of the venture. That's one of the reasons we form it, was to have a salary and to also take out profits. And remember, profits come out at a lower tax rate. Salaries come out at a higher tax rate because they have employment taxes associated with them. So oftentimes it's important that the shareholders are able to take out profits or dividends because they do come out at a lower tax rate. And then finally, and this is one of the reasons that these cases have such emotional turmoil and motivation in them, it's not uncommon for people who've invested in these companies to have invested their life savings in them. And therefore, when any of these scenarios that I've described takes place, people are desperate. They are desperate, and I'm telling you this. So as lawyers, you appreciate the emotions that you deal with sometimes when you are dealing with clients who are subject to any of these freeze-out techniques or perceived freeze-out techniques that we're talking about. It can be pretty dire for them. All right. Mentioning before, valuation of closely held businesses. So let's say that there is a transaction to buy out a shareholder in a closely held corporation. We don't have stock market to set the price. We pretty much only have what a willing buyer and a willing seller will pay for the shares of the private company. And that being said, again, closely held companies being largely creatures of contract, as we've talked about before, aside from a lot of statutory provisions, we always have these clauses that say unless otherwise provided in a articles or in bylaws or in a contract, this is what governs. So closely held businesses are often governed by negotiated contracts that contain valuation formulas for valuing the shares of the closely held company. And here's a few of them, just to give this to you as we finish up this segment on dissension in the closely held corporation. Agreed value. With this method, the shareholders annually set the value of the company's shares, and that remains in place until the next agreed valuation. The parties can come up with this price any way they want. They can roll the dice, they can use the Ouija board, they can simply come up with a number they like, and given that time that they set the value, it remains the same for the next year. Any buyout transaction that happens within that time period becomes the price of the buyout. No negotiation, no discussion. Obviously it's simple, and some clients of mine actually use this. Another way to value shares in a privately held company is the book or asset value approach. Now this is one of the easier methods to apply because you simply use the historical cost of the assets minus any depreciation, that's also known as write-down, and you then deduct the business's total liabilities. The only problem with the book value or asset value approach is that if there's any increase in the value of the business and the value of its intangibles or its goodwill, that's not taken into effect in valuing the business on an asset basis. The asset basis is generally a lower value than a fair market value approach. Another way to value private companies is what we call the income or earnings approach. In order to properly project a business's future earnings, you can look at cyclical trends in its past earnings, usually over a past cycle of, say, 4 or 5 years. And the way this usually works is that you take a multiplier of what we call the trailing earnings average. So let's say you take the average earnings over a period of 5 years. You multiply it times a chosen multiplier that can be based on the industry you're in, say 3 to 5 times that average trailing earnings number, and that's the figure you come up with for the value of the shares, the value of the company. Another approach is to capitalize the business's earnings and multiply this by the price-earnings ratio of similar companies that are public in order to determine this private company's fair market value. And the challenge here is, of course, to find a comparable company to use for your benchmark. Yet another way to value private companies is what we call the dividend approach. And this is, you look at the business's dividend payment history or profit distribution history, and you capitalize it based on the dividends paid by similar public companies. Again, this has to do with the actual distributions by the company in the past. And then finally, a very common way to value private company shares is to take the fair market value. This looks at similar companies, comparable companies, usually public companies in similar industries, and requires a certain amount of analysis to come up with the fair market value of the shares of the company. All of these valuation methods whether it's agreed value, book value, income approach, dividend approach, or market approach. Typically, you engage an outside accountant or someone who specializes in valuing private companies, and there are a lot of people that do that. So, summary. Private companies, we have statutory mechanisms for resolving disputes. We see that courts will interpret those statutory provisions in a number of different ways, based on the statute, based on the activism of the bench that's looking at the statute, based on equities. We also find that we can write deadlock provisions into our contracts for resolving deadlock disputes, and that those are the most effective way to resolve these without the involvement of the court. In terms of dissension, we've learned that majority shareholders clearly have a fiduciary duty to minority shareholders, and that there are a number of ways that majority shareholders can abuse their position of power through oppression techniques, freeze-out techniques that take advantage of the employment situation, the dividend situation, and any of a number of financial stakes that the minority shareholder has to the company of which he's an owner. This video should be up on YouTube for everyone to view. We'll do a similar approach to the mid-year review that was to take place this week, and next week we'll proceed to talk about insider trading. Point that I was 1701 MBCA 1430. I told you I don't look at the Model Business Corporation Act a lot, but sometimes I do when it has something that's illustrative of what you might face practicing in another jurisdiction. Again, I can't hyperlink that on this PowerPoint format, but I will. It is up on the website, and if you read it, you'll see that one of the factors that the courts can use to determine whether it's appropriate to judicially dissolve the corporation is whether there's been, quote, instances of corporate waste. This is a brand new factor from the ones we've looked at so far, at least from a statutory standpoint, where we have the MBCA provision specifically authorizing the potential for judicial dissolution in the case of corporate waste. If there's excessive salary, if there are sweetheart deals being given to insiders, all of the other instances that we've looked at so far in the semester when we've talked about corporate waste. So similar to Ohio, except for that wrinkle, the corporate waste clause for judicial dissolution. Okay, I want to back up to talk about the last topic I want to cover in this lesson is valuation of closely held businesses. When we have shares traded on a public stock market, obviously it's easy for us to obtain a current market price because the market price is set by where the stock is trading in a particular time. We have readily available valuation. But with private companies, how do we determine share price? This is important in any of the number of the buyout transactions that we've talked about so far in this lesson, whether it's a judicial buyout or a negotiated buyout. How do we come up with the price? As in all situations involving closely held companies, we have the ability to contract for this. And just like we have contractual dispute resolution provisions, we can also include in our closely held corporation agreement or our shareholder agreement how we're going to value the shares in the event that there's a transaction triggered by any of the events that take place under the shareholder agreement or in any other situation, whether it's a judicial buyout or a negotiated buyout transaction. Here's some valuation methods that are commonly used for closely held companies for you to keep in mind. These are typically drafted into a shareholder agreement. The first one is agreed value. What is agreed value? It's what the name says. The parties agree every year what the price of the shares will be, and that price remains the same until the next annual price setting event. And it's usually set up to happen every year. So you have an annual valuation, you create an amendment to your shareholder agreement setting forth the price for the ensuing year, and the next year you do it again. How do you arrive at the price in an agreed value scenario? However the parties decide. It can be based on some reason, it can be based on pure chance, it can be a Ouija board. It's however the parties decide. But the idea here is that if any event takes place during that year that requires a valuation of the shares, we have an agreed value. It avoids time and expense. Of course, the risk is that what happens if the price, if the true value of the shares has changed significantly during that 1 year period, you won't capture that change in value up or down. But it is simple, and a lot of people use it, that's one viable option. Another one is the book value or asset value approach. And we'll sometimes see it provided in an agreement that in the event of one of these transactions, one shareholder will buy out the other at the book value of the shares. Book value is pretty easy to figure out. You take the cost of the assets minus any depreciation or write down that may have been taken with respect to those assets for wear and tear or loss of value over time, and then you subtract the liabilities of the company, and this gets you to a net asset value of the company, which you divide by the number of outstanding shares, and voila, you have book value per share for the company. This is based solely on the asset value, and it's very specific. It's, I would say, a relatively low value. It doesn't take into consideration anything like goodwill or going concern value or perceived value, these intangibles that sometimes affect stock prices. It's purely an asset-based valuation. It's easy to prove, it's easy to establish, but it does have the drawbacks that I just mentioned in terms of not reflecting any intangible value of the business. Another way to value a privately held business is with an earnings approach or an income approach. And in this type of scenario, you typically look at the historical earnings of the company for a look-back period of several years, typically 5 years. And you look at what the average profits or earnings were during that period, and then you multiply it by a multiplier that tends to be industry specific and based on custom as much as anything. So for instance, if we have let's just say we have a company that makes widgets, it could be that the current multiple that's being used to come up with an earnings valuation for shares is 5. So if we had average earnings over the prior year of $1,000 a year, multiplied times 5, that would give us the large number for the total value of the company's shares, and you would divide it by the number of outstanding shares to get to a per share value. This is an inexact process, but it's an attempt to come up with the future potential earning power of those shares. Another method that's commonly used is the dividend approach. This is similar. It looks at the dividend or profit distribution history of the company in the past, and it looks also at similar public companies where we have this kind of information. And the idea here is to, again, come up with some kind of a multiplier based on the profit distribution or dividend potential of the company, looking at a past snapshot of how they have historically distributed profits. Again, it's not a guarantee, it's just a best estimate at what the potential profitability of the company will be. And then finally, another method that's frequently used is the market approach, or the what we call the fair market value. In this type of a scenario, typically you will hire an outside firm who will engage in an analysis of the marketplace, looking at public companies whose information is readily available, and determining what the likely fair market value of your private company is based on the valuation of similar public companies. And again, this takes into consideration not only assets, but prospects and possibilities, goodwill. We all know that a company like Google trades for a very high price, which bears very, very little relationship to its assets. And most of that value is seen as the strategic or potential of that company to generate profits in the future. So this fair market value approach also looks at these types of intangible factors that may contribute to coming up with a fair market value. In this case, again, whoever's doing the analysis would come up with a fair market value for the entire company, and we divide it by the outstanding number of shares, and that gives us the fair market value of a given share. I use this methodology in a lot of the agreements I write. Again, this requires typically hiring a third party, and the price of that is paid for by the company, which has the effect of, again, causing some pain to the parties, and perhaps encourages them to come up with a realistic value on their own. That is a negotiated price, rather than having to take a haircut by the companies spending money to come up with a valuation because they simply weren't able to come up with a valuation on their own. So a number of ways to do this. There are firms out there that make a living at valuing closely held companies. I want to mention a couple of other concepts having to do with valuing closely held companies. Again, this all is relevant to how these dissension situations play out. One of them is a control share premium. The concept here is, if I'm buying into if I'm going to buy shares of a closely held company, arguably the shares owned by the majority shareholder are worth more. Why? Well, simply because in the normal situation, and I'm not talking about any of these oppression situations we've been talking about, I'm talking about just general corporate governance rights of a majority shareholder, you have the ability as a majority shareholder to significantly influence the direction of the company and to control the company in a lot of ways. Therefore, there's the concept of a majority shareholding premium, that if you come up with a share price for a company based on any of these methodologies that we've come up with, shouldn't there be a premium that is an increase in the per share price for the shares owned by the majority shareholder because of its ability to significantly control the direction of the business. And then, of course, there's a converse concept called a minority share discount. And the idea here is we may come up with one of these price per share calculations that we've been talking about, but again, if the transaction involves the purchase of a minority stake in the company, shouldn't those shares be valued less than the shares of the majority shareholder? Again, because the relative lack of ability to influence the strategic direction and the finances of the company. So minority discount, majority premium are kind of an extra layer that gets factored into valuation of privately held businesses. Okay, just a very brief summing up of what we've talked about in this lesson. Deadlock is something that happens more often than we'd like for lots of reasons, having to do with the dynamic of starting up a business. The best way to avoid any situations involving deadlock is to write them into a contract, to have a provision in the contract that eliminates the possibility of a permanent deadlock once those mechanisms are called upon by the shareholders. Courts will get involved in resolving deadlocks, but they prefer not to. Courts will sometimes look at the profitability of the corporation as a factor in deciding to break a deadlock. But in Ohio, we've seen that courts need not consider the profitability. Resolving a deadlock as a judicial solution is an equitable remedy, and courts are loath to employ those types of remedies if there's an easy way to avoid it, by, for instance, finding that someone has violated the corporate governance provisions that they agreed to in the first place, or by directing the party to some other solution to resolving the deadlock. In terms of oppression, or what we'll refer to generally as freeze-out or squeeze-out techniques employed by a majority shareholder, there are a number of ways that a majority shareholder can put pressure on a minority shareholder due to the fact that generally shareholders of closely held corporations rely on those corporations for their jobs. They rely on the distribution of profits, and there are any of a number of ways that an unscrupulous majority shareholder can seek to employ these devices in addition to any legitimate advantages they may have as a majority shareholder. We've seen that majority shareholders clearly have a fiduciary duty to minority shareholders under any of a number of cases we've looked at. They have to account for what they do. Everyone should be treated the same if they have the same shares. Remember that from the first week of class. So courts won't hesitate to find a breach of fiduciary duty where there's waste, where there is squeeze out of a shareholder of that shareholder's rights. And of course we have the maxim from Meinhardt versus Salmon that stockholders of closely held corporation owe each other a fiduciary duty the same as partners. We looked a little bit also at some of these judicial resolutions for dissension, and there we do have statutes. We've looked at statutes. In Ohio, those tend to be pretty mechanical, and it can only be employed if you have very specific mathematical disputes or deadlocks between the owners or directors of a corporation. We don't have unlimited or even limited equitable powers on the part of a court in Ohio, at least I would submit, and that courts are loath to dissolve a company due to the impact that this might have on other stakeholders, employees, vendors, suppliers, and so we find that courts are loath to engage in judicial dissolution of corporations. That's all for this lesson. Thanks for listening.